Philosophy 212, Ethics in Business and Society. In this lecture, we will explore employee privacy as it relates to drug testing. Privacy is defined as freedom from unauthorized intrusion. Generally speaking, the idea is that before someone can look into your personal life, your belongings, your body, etc., that person must have the authority to do so and a good reason. The standard drug test looks for metabolites of the following drugs. The most commonly used illegal drug is marijuana. It is also the drug most likely to be detected for two reasons. It is the most widely used, and it stays in your fat cells even after the psychoactive effects of the drug have worn off. At additional expense, an expanded test may be used. Since drug tests are a cost for a business, there needs to be a good reason to administer such tests. There are arguments for and against employee drug testing. What are the arguments? An argument is an attempt to convince someone using reason. The arguments we use in this course generally have a principle combined with one or more alleged facts, which are offered in support of a conclusion. The conclusion is a judgment or an evaluation. We will now go through each argument for and against employee drug testing. After each argument has been presented, criticisms of each of the arguments will be provided. Two arguments in favor of employee drug testing are the productivity argument and the harm argument. There are two versions of the harm argument. For employee drug testing, the productivity argument. The goal of business is to maximize profits. This is the business principle. Use of some drugs lowers productivity. This is an alleged fact. Lower productivity leads to lower profits. Another alleged fact. Drug testing can reduce drug use. Again, an alleged fact. The conclusion: drug testing is permissible. We see in this argument a principle and three alleged facts offered to justify or support the conclusion. For employee drug testing, the harm argument, version 1. The goal of business is to maximize profits. Once again, the business principle. Use of some drugs impairs employees, leading to harm to employees, customers, and the public. Harm can lead to loss of profit due to lawsuits and insurance premiums. Drug testing can reduce drug use. These are our alleged facts. The conclusion: drug testing is permissible. A second version of the harm argument is as follows. You should do the right thing. This is the highest level ethical principle. A lower level ethical principle is that you should prevent harm if reasonably possible. Again, our alleged fact that some drugs impair employees, leading to harm to employees, customers, and the public, and that drug testing can reduce drug use. The conclusion: drug testing is permissible. In this case, we have arrived at an ethical judgment. Two arguments against employee drug testing are the privacy argument and the probable cause argument. Against employee drug testing. The privacy argument. Everyone has a right to privacy, an ethical principle. Drug testing violates the right to privacy, an alleged fact. Conclusion. Drug testing is not permissible. Against employee drug testing, the probable cause argument. No one should be searched without a good reason. Such a reason is called probable cause. Drug testing is a search without probable cause. Conclusion. Drug testing is not permissible. We have looked at the arguments presented formally with principles and alleged facts made clear. But as philosophical thinkers, it is not our job merely to accept arguments, but also to think about them critically. There are standard criticisms of each of the arguments. The main objection to the productivity argument is that there are many different causes of low productivity. For example, an illness or marital troubles may cause low productivity in an employee. However, those are private areas that are not themselves relevant to a person's work. What matters is the poor performance, not the cause of it. An objection to the harm argument is that not all jobs have the same possibility for harm. For example, the job of driving a truck or piloting an airplane has much more possibility of causing harm than, say, a college professor. When it comes to privacy, an employee may agree to waive certain rights for a job. A job involves a contract between worker and employer, in which the employer agrees to pay certain wages in exchange for the worker's labor. Certain other features, such as agreeing to a drug test, may also form part of the employment contract. As for probable cause, a reply to that argument is that an employer could have drug tests applied to all employees, or to a randomly selected subset of employees. In that case, no individual is being singled out without probable cause, and so the process seems fair and avoids this argument. Now we turn to the legal perspective on drug testing. We will only briefly look at the law relative to this topic. More details may be found in your assigned readings. The Fourth Amendment to the U.S. Constitution states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Courts have interpreted this amendment as protecting a right to privacy, that is, a freedom from unauthorized intrusion. Without probable cause, you may not be searched. The legal question, then, is whether drug testing violates the Fourth Amendment, whether it is a search without probable cause, that is, an unreasonable search. In Skinner v. Railway Labor Executives Association of 1989, the United States Supreme Court decided that federal employees in safety-sensitive positions may permissibly be drug tested. This case served as a precedent for future cases. In Board of Education v. Earls, the United States Supreme Court ruled that public school students involved in extracurricular activities may be drug tested, since participation in such activities is voluntary. In a related case, the California Supreme Court ruled in Hill v. NCAA in 1994 that drug testing college student athletes did not violate their right to privacy under the California state constitution. In this presentation, we have looked at important issues and arguments related to employee drug testing. The intersection of privacy, profit, public safety, and moral obligation provides much food for thought.